Hi, everyone. Welcome to Module 8. More than halfway through the course, and you should all be proud of yourselves for making it this far. So we're going to be pushing on some of the aspects of the court system, the second phase or the second branch of the criminal justice system this week. In particular, I wanted you to focus in on and have an understanding of plea bargainings, what the purposes of plea bargainings and the advantages, disadvantages. Essentially, are there abuses that occur within the criminal justice system or the court system with regards to plea bargaining? One of the things that you really should keep in mind is that plea bargains are a tool that are used essentially to lessen a sentence, but guarantee a guilty finding by the court. They cannot be appealed in any way. Once an individual accepts that they accepts a plea agreement, they are accepting a guilty verdict without having to go through trial and wait for the jury to make a decision. Now, what would be the advantages and disadvantages of doing that? Well, the advantages is that you're agreeing to a lesser charge that the prosecutor is offering you. So you could be in for drinking and driving, which would be a loss of your vehicle. It could be something fairly significant and costly. You might lose your license. You might plead down to disorderly conduct, which is a far lesser charge. You don't have to worry about losing your vehicle. Your insurance rates don't go up. So there's a significant advantage to taking the plea bargain. The disadvantages is that plea bargains are often offered by the prosecutor to the defense attorney and then brought and presented to the client or the defendant. Now, who might want to take advantage of a plea bargain under certain circumstances? We have to keep in mind that public defenders are free and they're provided to anybody that cannot afford an attorney. You should know this through watching television and the movies that under the Miranda rights, beyond the what you say and what you say will be used against you in a court. It's if you cannot afford an attorney, one will be appointed to you. So everybody has the right to counsel here in the United States. The problem with that is that most public defenders are overburdened. They make less than prosecutors, have the same level of education, and then they're stuck with so many cases, and it's a lot easier for a public defender to say, yes, the plea bargaining is a better option for you as a defendant, and I don't have to go to court, which doesn't take up my time, and I can move on to my next case fairly quickly. The problem is when a public defender is always looking for that plea bargain. It's because once the defendant, again, agrees to the plea bargain, they're agreeing to a guilty finding, which means that there's never a chance to appeal the decision because you agreed. The finding might be guilty, but you've agreed to being guilty. So once a defendant agrees to being guilty, you can't go back on it. There's another part to the plea bargaining. Now, it might be a perfect scenario where the prosecutor looks at this and says, let's just plead this down. The defense attorney says this is a much better deal than going to trial and possibly instead of doing 6 months in a house of corrections, you might be doing 3 to 5 years at a state or federal prison. And the defendant might go, I'm definitely guilty of this, but you're going to give me a lesser charge. I'll jump on it. It's better than me doing time a longer period of time inside of a prison. The caveat to this is that the judge has to agree to it as well. And the judge can turn around and go, no, we're not doing this. This defendant is clearly guilty. The evidence is leaning to that. Whatever reason why either side is agreeing to this, I don't agree to it. The people deserve their justice, and we're going to trial on this. And then that throws the whole plea bargain right out the window. So plea bargains have advantages and disadvantages. I've given you a few for the purposes of this brief overview of the week, but I really want you to dig down deeper and to come up with some more examples of why it's advantageous or a disadvantage for a defendant to take a plea bargain. The second part of the second thing that we should really discuss is due process. This is also part of this week's discussion. So the Fifth Amendment basically states that no one person shall be deprived of life, liberty, of the pursuit of happiness, or property without due process. So we understand this under the Fifth Amendment. It was again brought up in the 14th Amendment that the same words were used, identical words were used, which also forced all of the states to say that you cannot deprive any individual, any American citizen of life, liberty, and property. You can't just go seize their things. You can't take their freedom away and lock them up. And it basically said, this is what you need to do at the state level. So originally, the due process was really just not that pushed. It wasn't something that came up often in the early part of the country. And it wasn't until that Barron versus the city of Baltimore in 1833 that it became an issue and was really pushed. Again, it really gained its founding in 1905 with where Larkner versus New York. Basically, New York had created a law and said, and I just want to start this off, it's not taking away the liberty of somebody. This isn't their freedom that they're being deprived of. They're not going to prison, and nobody's going in and taking their goods away. Due process also works in other ways. In the Larkner versus New York case in 1905, basically the New York said that bakers could only work a certain amount of hours, and the bakers in New York went, you can't tell us how many hours that we can work. You're taking our due process, our liberty, our ability to do whatever we feel that we need to do. And it doesn't harm other people. So they sued, and the Supreme Court ruled in the bakers and Larkner's in all of the bakers' favor, saying, due process, you cannot create a law that takes away liberty, somebody's ability to earn a living or to spend time. So I want you to explore due process, understanding that the Fifth Amendment and the 14th Amendments are critical in understanding the due process. So the writing assignment for this week is about the burden of proof. And it's understanding the differences between civil cases where, like, if you slipped and fell inside of a Walmart, versus a criminal due process where that the jury must convict you as guilty. Now, think about this. In a criminal, our founding fathers essentially said criminal liability is far greater than civil liability. And I'm going to explain that. So criminal liability is essentially taking somebody's freedom away. Now, were they liable, and do you have the right as the state, the jury, to take somebody's freedom away? The founding fathers said, this has got to be really absolute. If we're going to take somebody's liberty away, their ability to move freely through society, and lock them up in a prison, then we've really got to have everybody on the jury agree to it. Makes sense. So a 12-person jury has to agree 100% to take somebody's freedom away. That means that if it's a criminal trial, somebody's sitting down and saying, this person's guilty. Everybody on the jury has to say, yeah, that person's guilty. And only if that's done will the person be found guilty and then placed in a prison or other type of thing that's going to impede their freedom. The difference is it's beyond all, well, in a criminal trial, that's called beyond a reasonable doubt. Now, the difference lies in the civil trial. You can take somebody's money away and not their freedom. So the founding fathers said, we can adjust this a little bit. It's not beyond all reasonable doubt. It's the preponderance of the evidence in a civil trial. The phrase is preponderance beyond preponderance beyond the evidence. So in other words, you need only 51% of the jury to say that you're guilty, and then you're guilty. So there's a far different way on this. So we have to keep in mind that there's this component of the court is the jury, the separation between criminal and civil trials. And then we look at the dual court system in the United States. So the dual court system, in its simple way of looking at it, is the federal system and the state system. They look very similar. In the state system, we have our district courts, our superior courts, and our state Supreme Court. Now I'll get into jurisdiction in a second. So those are that's the level of state courts. Now at the federal level, you also have a district court, you have a circuit court of appeals, it's a circuit court of appeals, And then you have the Supreme Court. And the Supreme Court is essentially the law of the land. There's no other place that you can appeal a case. So if I'm a criminal and I get arrested in Massachusetts and the police officer did not read me my rights that we talked about earlier, the Miranda rights, then I can appeal my criminal conviction at the district court level to the Superior Court level. And at the Superior Court level, I can essentially say, you know what, I wasn't read my rights. I didn't know what my rights were. And the officer didn't give me my rights. So I don't think I should be found guilty. Well, the state Supreme Court says, sorry. Well, the Superior Court says, sorry, we don't agree with you. We're going to rule in favor of the district court. Well, I don't like that decision as the defendant. So I'm appealing that decision to the state Supreme Court. The state Supreme Court hears all of the evidence, and they rule with the lower court, the Superior Court. Wow, what can I do as a defendant? Well, I can now take this to the federal court. And this is where it comes into jurisdiction. Jurisdiction is not a geographical boundary. A lot of people confuse that. Like you watch the old movies and they say the sheriff is going to bring you to the county line. Well, that doesn't exist in courts. There is no line. There is no, this is the power of the court from here to here. Other than the state, there is a state jurisdiction. But when we talk about court jurisdiction, it's the types of cases that they can hear. So a district court can only hear cases at the district level, if we're talking criminal, at the district level that fall under misdemeanors. Anything higher than a misdemeanor has to go to the Superior Court. So that is called a general jurisdiction. Now we move into the Superior Court. Superior Court has two types of jurisdictions. They have the general jurisdiction to hear felony cases, and they also have the ability to hear appeals, and that's called the appellate jurisdiction. So the state Supreme Court only has appellate jurisdiction. They can't find somebody guilty. They can only listen to a case that has been already found guilty. So when we move into the federal court, it's the same thing. The district court has general jurisdiction. The circuit court has appellate jurisdiction, and the Supreme Court has appellate jurisdiction. The Supreme Court cannot try a case and find somebody guilty. They can only listen to cases that have questions on constitutionality. So that gives you a little bit of the jurisdiction and the dual court system. Understanding the dual court system is the federal and state system, and jurisdiction is the types of cases that a court can hear. Now we move into the understanding the adversarial system versus the acquisitorial system. So in the United States, we have the adversarial system, meaning that you have two sides that walk into court and they argue their cases, and the judge remains impartial throughout the entire process. Doesn't have a dog in the race per se. They just listen to the case, making sure that procedural law is followed and that constitutional law is followed. Other than that, the judge just sits there and listens to the case and essentially takes all of that information and makes a determination based upon the two sides arguing. In an inquisitorial system, in say France, Italy, Saudi Arabia, the judge has a direct role in the case, the prosecutor's side of the case. So think about that for a second. You're a defendant and you're trying to prove your innocence, and the judge isn't there to listen to you. Well, they're going to listen to your evidence, but they're really on the side of the prosecutor. So not only are you getting hammered by the prosecution, but the judge is part of it. So it's not really fair. And that it's important to understand that how flawed our system is, it's set up to be as fair as it possibly can within the court system, within procedural law. So that's it for this week. I really hope you enjoy the week. And if you have any questions, please don't hesitate to reach out to me. And again, you can always ask me questions by text or by email, or if you schedule a Zoom with me. If you have any questions, I look forward to chatting with you. Have a great week. Bye.